panel on the stage. We have our moderator with us, Shri Ajay Kumar, Managing Partner, KLA Legal. I'll request you, sir, to please join us here on the stage. Next up, we have Shri Ajay Kharbanda, Chief Legal Officer, GMR Airports Limited, North and West Sector. We have Professor Dr. G.S. Sachdeva, Professor Emeritus, Chandigarh University, Punjab, and Adjunct Professor, Nalsa University of Law, Hyderabad. We have with us Professor Dr. Sandeepa Bhatt, Professor of Law and Director of Center for Aviation and Space Laws at National University of Judicial Sciences, Kolkata. As, ladies and gentlemen, all our panelists are joining us on the stage, I'm going to hand over the stage to our moderator, Shri Ajay Kumar. Sir, the stage is going to be all yours.
Thank you so much. Thank you so much. Good morning, ladies and gentlemen. First of all, thank you so much, NLU and Aviation, for giving me this opportunity to moderate the first international conference on aviation law in India. Just to introduce myself, my name is Ajay Kumar. I am the managing partner of the law firm KLA Legal. We have been working for various stakeholders in the industry, including aircraft lessors, financiers, lessees, government, as well as other ECAs and lenders. So this was my brief introduction. May I now invite the esteemed panelists to speak a few words to introduce themselves before we start the session. Thank you.
Good morning, everyone. I'm Ajay Kharbanda. I work for GMR Airports Limited on the litigation handling their India issues on the north and west sector of the airports. Currently on the north we have Delhi and Goa airports. Besides, I also support my organization for our international airport issues on the legal side. We have currently the airports operating at Cebu, which is in Philippines. It's in Medan, which is in Indonesia, and one new airport is coming up in Greece, a place called Crete. So we have a footprint besides that also in India. My role is to support the team on the legal and regulatory aspects of the airports in India and international side. Thank you.
I am Dr. Sachdeva. I am Professor Emeritus with Chandigarh University, Punjab, and Adjunct Professor with Nalsa University of Law. My basic specialization ranges on two subjects: aviation law and outer space law. In fact, I can give you my background that for 25 years I served in the Indian Air Force and retired as Wing Commander. So I have a fairly good idea of not only the public air laws, but also how the MRO works, how the different maintenance systems. It works now. After my stint in the Air Force for 25 years, with regard to maintenance, logistics, and various other aspects, when I retired, I started working on air law. My first book was on carriage by air, liability. And it was published in 1987. Since then, I've been having certain assignments from different universities like JNU or NUJS Calcutta or from JNLU Ahmedabad, JNU itself, and I've been doing the teaching work. While working on the air law, I drifted to space law. And my first work on space law was in 1996. That was on space tourism, when people looked askance as to what is he talking about. And today when I look in their eyes, I find I'm right. Space tourism, space travel has started, and it will grow, it shall grow. Anyway, today I'm an autonomous writer. I keep writing on my own and publishing. And as on today, I have about 10 books to my credit, solo authored, and over 70 articles. Thank you very much.
Very good morning to all of you. I'm Sandeep Bhatt, Professor of Law and also Director of Center for Aviation and Space Laws at National University of Political Sciences, Kolkata. Yes, I work, again, just like Professor Deva, both in aviation as well as space. And I should say predominantly space because I mean, it's very close to my heart. So that's the reason why I should consider myself more as a space lawyer rather than an aviation lawyer, despite the fact that I work also extensively in aviation law and also teach my students in NUJS. Fortunately, I also happen to be the first Unidruva correspondent for the India, which works in the field of aviation financing, and even the space financing matter might also come up in the near future. So this is all about my introduction. Thank you.
Thank you for this lovely introduction. We are really privileged to have such esteemed panelists, with us, and we should take full advantage of their knowledge. There should be a lot of learning. I wish there were more students here, but those who are listening, please, make sure that you learn with these, bright minds. So, with this note, may I invite Dr. Sachdeva to speak on new thinking towards passenger liability.
Thank you very much.
Thank you.
The subject I'm going to speak on, you can see it on the slide itself. To begin, aviation law is a recent creation. It didn't exist. Since a long time. And today, the way the law has developed, the aviation law, we can divide it into 4 categories or classification. The first.
It is just being put on the screen.
Okay.
If we request for 1 minute, sir.
The first one I would put it as public air laws, which includes the Chicago Convention, which is the basic aviation regulator. Then the freedoms of the air, where aviation really goes out. Thank you. I think we can.
Yes, thank you.
Next, please. It's not.
I'll change this.
Thank you very much. I'm not tech-savvy.
Neither
I'm
am
not
I, but
tech-savvy at all. Fine, thank you. No, my idea is just to give you a little background as to how these laws have evolved. So we have that sort of a Chicago Convention, freedoms of the air, and the air traffic management. These are all international. Then we have the criminal air laws, something like terrorism which was there in the 70s, or hijackings, and offences against flight safety. Some of these I'll discuss in my course of further discussion. Then are the privateer laws, where we normally talk of passenger and cargo liability and compensation for delays in the aircraft. And the last, which I have to mention, is commercial air laws, which are insurance, leasing, and also include Cape Town Conference, which is recent in the Indian legislation. Next one. Now, talking about passenger liability under the aviation laws, which is literally going to be my subject of talk today, I should put it that even before aircraft came, commercial aviation had started. And one of the earliest airline was a German airline called Deutsche. And this was started by a magnate of Germany, Zeppelin. They were not with the aircraft. They used to fly, and what they used to call it is blimps. These were the gas-filled balloons with a gondola underneath for the passengers. This operated for some years, much before the aircraft came. But unfortunately, there was an accident of one of the blimps, Hindenburg, at Lake Constance. And the liability at that time was according to the tort law. And the people who traveled by aircraft or this sort of a blimp were very rich people. And when it turned out to liability or compensation, it became unlimited and such a huge amount that Zeppelin and his company DeLog both went bankrupt. Then what to do? The other companies which were operating by that time, they started contracting out their liability. Like we know in the law terms where we can call it as ad impossibilia, or call it force majeure, or you can call it something like abundanti cautela, that we had taken abundant precautions, abundant caution on that. But in spite of that happened. So, but this was not the right approach, and this was not the legal jurisprudence of the time. So what really came about, what we have today, are the two conventions, the Warsaw Convention and now the Montreal Convention. Unfortunately, these conventions are not integrated. They are in layers, and different countries have accession to both or none or either. So with that sort of a situation, I'll briefly put it that air carriers are liable for compensation on paid tickets only. There are circumstances where unpaid invitations are there. Liability under the convention does not apply to that. The other is that liability arises in case of an accident of an aircraft. And it covers only either the physical injuries which are diagnosable or seeable, or the death. And then it restricts further that liability shall be admissible only to the passengers who are on board. And the definition of on board was, okay, it included embarkation and disembarkation. There were cases like the famous case of Mrs. Chuter, who after having embarked was right at the step of the aircraft and one step on the ladder when the ladder was removed and she fell on the tarmac. She claimed compensation. It was a different situation that by the time she preferred the claim, it came under limitation. I think lawyers would understand the law of limitation. It was more than 2 years, and the claim could not be admitted. And the conventions also brought about another aspect, which was a limitation, because we had behind us the experience of DILAG, where the company went bankrupt because the compensation claimed was so much that it could not be. Now, I'll cover some sort of a new thinking as to what exactly is happening today and where are we going? Where are we going? Now, today we come to an intersection where airports are becoming huge complexes. And it's not only that these are huge complexes, there are multiplying formalities right from the security, entering the airport, sanitization, you have immigration, customs, and the various other formalities till you get into the aircraft. Now, as a result, a passenger remains within the airport complex for a very long time, and many of you would know that you are normally advised to reach the airport 3 hours in advance of an international flight. Imagine the 3 hours. And then, there were certain, I would call cases or call it certain circumstances which happened. It happened in a case where the rooftop fell. And when the passengers were there, some of them got injured. Now the problem came that how exactly to tackle that. And that is where I'll go to the next one. I'll quickly go over because I'm running out of time.
No problem.
So, in fact, we were talking about, and it so happened in Tehran airport, the rooftop of a terminal fell down. When it fell down, there was injuries and there were cases. Now the question came, how do we do that? And that is where the US courts came and evolved a criteria. It was a threefold criteria. Where was the passenger? His location. Why was he there? His purpose. What purpose? What was really required for him to be there? And third was who or whose control? Whose control? Was he under the control of any agency, any regulatory authority, or for any reasons? And at the same time, it was that the sanitization of the airports, security, I'm only talking of security sanitization, was being taken over by the agencies, government and otherwise. So what exactly happened? There was a roof fall, as I just mentioned, at Tehran airport, where injuries were involved. And there was a case, and this happened in 1974. Larry Upton was one of the person injured who went to the court and claimed compensation. And that is where this criteria was taken into account and it was set. There was another case of terrorist attack. It happened where we have the check-in counters and all that. And it happened in Athens in 1973. Now, when the court had considered these three criteria, they said, yes, this will be treated as a time predicate before and after to the flight, and as such, any accident, any incident, any injury, whatever happens, shall be compensated. Then another aspect came. It's not only that we are within the premises, but while within the premises, we use, while within the premises, we used lot of facilities, lifts, escalators, walkways, and that's a case where at the Indira Gandhi International Airport occurred a death of a child. There was a case of a death of a child which got sucked into the escalator. This became a different issue altogether. Ultimately, the Supreme Court in India said, yes, this is a case where this will be treated as antecedent or post-flight, but would be liable for compensation. And ultimately, compensation was paid, though the accident occurred in 1999, but Supreme Court ordered compensation under the Warsaw Convention. That's why it becomes relevant to us in 2004. Similarly, we do not exit the airport till we visit the belts where we get our checked-in baggage. And it so happened once that Japanese, 2-3 Japanese were hired as proxies by the Palestinians. They picked up their baggage, opened it, pulled out the guns, and started indiscriminate firing. And that is where this was treated as well within the rule of Warsaw Convention. Second point which I made was that conventions only look at physical injuries. Now, physical injuries are the ones which are visible, diagnosable, and can be measured and all that sort of thing. But there are certain intangible injuries also which a passenger suffers. And I have listed some of the intangible injuries as trauma, angst, psychological distress, mental suffering, and so on. Now the question came, because the convention said that only physical injuries, are these injuries claimable? And that's where I bring in that case of Sachs versus Air France, 1985, where intangible injuries, there are other cases also, I've only mentioned one, where intangible injuries were deemed fit for compensation. Now I bring in non-accident deemed as accident. I had said that convention says if at all it happens in an accident and the passenger is on board. Now I'm talking of where admissibility of compensation is there and the person is, it's a non-accident case. There was a case of hijacking of passengers. Passengers were hijacked by Palestinians. They were taken somewhere, kept for one day, and returned. Nothing happened. Nothing happened to them. No injuries, nothing at all, only psychological. And that's where they got paid. Then was a case, I'm talking of non-accidents, unless you call hijacking as an accident. I'll just finish. There are cases of turbulence. There's a case of turbulence of Singapore Airlines where no accident, but turbulence took place and a lot of people, in fact one person broke his spine. It was held, and there was another case of Qatar Airlines where for 20 seconds the turbulence continued. So you can imagine the condition of the passengers inside. Anyway, whatever be, it was held that such cases shall be covered and compensation shall be paid. Because an accident is an unexpected, unusual, unintended happening. And in the end, I'll talk of a new type of injuries which are coming up on board. there's a case of sexual harassment and it happens to women.
We'll wait for the mic is
Yeah,
on.
mic is on. There was a case in 2012 where a passenger would look at a lady and would continuously stare at her. He was told that no, this is not right, or this is not correct within the discipline of a passenger. He still continued, turned violent. When he turned violent, it became a criminal offense. Well, it was a criminal, and similar things have happened. When drunk, they say so, that they were drunk or inebriated. And what we call this as a pee gate. They go and pee on a lady passengers. How a drunk or inebriated person selects only a lady passenger and not any other within the cabin is beyond my comprehension. But this is what happened. And this has not happened once in a while, it happens quite. Even a couple of days back it happened with Air India in the business class where a person did it. Now, I would bring you to an intersection of thought where these are criminal offences and are to be handled according to the law of crimes. But they also come in a way because these are the offences which have caused, inconvenience, indignity, or perhaps something unexpected. It becomes an accident, unexpected, unusual. If at all it's unexpected, unusual, would a passenger be entitled to claim compensation? That's a thought. And I leave it to you because it's not once, it's not twice. It's a P-gate which is happening again and again and again. They take away the passenger, they try for something criminal. But what happens to that lady who's undergone that suffering? I leave you with a thought how this problem would be sorted in the future. Thank you very much.
On recent development in Indian aviation laws. Thank you. Yes.
All right. So, distinguished dignitaries on the dais, ladies and gentlemen, very good morning to all of you. It's good to see National Law University Delhi coming back on track to the aviation law. When I'm saying back on track to the aviation law, let me also tell you that this is not the first conference hosted by NLU Delhi. That was the first conference hosted 12 years back here, which was also in association with the Dubai Associates at that particular point in time. This is not my PPT. Right. So I believe that actually this association with the Aviation would continue, and also more of these kind of conferences would happen in NLU Delhi, and more work would happen in aviation law. Of course, most of us, my own friends and colleagues here, would definitely be willing to contribute for this aviation law center and any endeavor which happens in the NLU Delhi. So I hope that this kind of exercise will become more frequent. Now, coming to my presentation, I would like to have the PPT on because there are a couple of provisions which I need to show you, otherwise I will not be able to make any sense to you. So please, whoever is handling the PPT, kindly keep it on place.
Just give us a few seconds. It's being.
Come.
Thank
Yes,
you.
come. Right, thank you. I'm speaking on recent developments in Indian aviation laws, especially the two which have happened in the last 4 months, because December we had the BVA, And very recently, a week back, we have the Cape Town Convention, the Act. So I'll be speaking on these two developments. Why is it not moving? Technology, yeah. Wow. In the Indian aviation, India has been a forerunner, to be very precise, because maybe to a greater extent thanks to the British administration, who wanted to have the development of aviation in India, maybe for their own strategic advantage as well as the administrative reason. 21st century, we again had a revolution in flying with Air Deccan entering into the market. Because until that time, civil aviation was not considered to be the common man's the dream. Air Deccan has resulted in revolutions in Indian sector, which made even the common people to dream of the flying. The fares have gone down so much that one can afford it, and then ultimately even the common people can fly with this. Unfortunately, it has also got its own flip side in terms of the aviation. Competition between the airlines, right, those who are already well established, competing with the low-cost the budget airline like the Air Deccan was a difficult scenario in India, resulting in unhealthy competition and many airlines undergoing the bankruptcy proceedings. At the same point in time, we are also having problems with infrastructure. Airport infrastructure, of course, airports have doubled over the period of time. Precisely last 10 years, it has doubled. But in terms of infrastructure, we are still not matching the international standards. We had a very recent project, a major research project on the airport infrastructure. We picked up 4 major airports and also 4 second-tier airports. We found there are still so many requirements which need to be complied with respect to the international standard. Anyhow, so there are concerns, but at the same point in time, I am not going to say that aviation is bad in India. It's not the scenario. We need to cater to the huge market which is in India. Now, yeah, okay. So, Bharatiya Vayuyan Adhiniyam. Okay, sorry, Adhiniyam. 2024, the legislation, which has replaced the Aircraft Act. Of course, many people started saying that this is just actually the change of the title from English to Hindi. And even the southern states had got reservations, but that's all different things. So let me not delve into that particular aspect. Let me delve into what has been done in the new Adhiniyam. I should say predominantly this has made a change in the preamble. Preamble has become more inclusive now. Design, which was not mentioned, aircraft design, which was not mentioned earlier, has been included within the ambit of that. And in addition to that, any incidental aspects or related to the aspects of regulation and control, which were mentioned earlier, have been covered in the preamble. And that is the major change. That is a major change because earlier, even the safety and security aspects were not mentioned in the preamble. Now those matters related to and incidental thereto, whatever has been included therein, is giving sufficient scope for safety and security aspects even covered in the preamble. And accordingly, Section 10 of the Act specifically mentions about the powers to make the rules, right? When it is mentioning that, it's also mentioning about aircraft safety as well as the security. So both of them are covered within the ambit of Section 10. So it is a kind of a development. Added to that, enormous powers are given to the central government, which definitely is not a problem because legislation cannot lay down everything. There's a requirement of delegating the power to the government. Rules, regulation, bylaws need to come up with respect to handling those the aspects. And one of the interesting changes is again Section 21 here, which has provided the power to delegate. I was always arguing earlier, all rules and regulations, whatever has been made by the DGCA, has been hit by the principle of delegatus non potest delegate. Because the parent legislation never gave the power to the central government to delegate the power earlier. But now there is an express provision under Section 21 to delegate that particular power. Right? So therefore, in that sense, these are all the developments which have taken place in the Bharatiya Vayuyan Adhiniyam. Now, what are the concerns? I don't think major concerns, but still there are few. There are few in the new Act. One is about Section 22. Most people must have heard about that with respect to the arbitration. whenever there is any compensation to be paid due to a loss or injury which has been suffered, consequent an order by the government, there is a requirement of settlement of compensation with the private player, maybe through the mutual settlement initially. The first process is mutual settlement. If it doesn't work out, then it should be through the arbitration. That's what Section 22 says. Section 22(1)(b), if I'm not mistaken, says about arbitration. But the arbitrator is supposed to be appointed by the central government, which is again not something acceptable, because when you look into the process of arbitration, both the parties need to agree for the arbitrator, appointment of the arbitrator, which has also been held in the Core 2 judgment last year, right? The Supreme Court has held that there is no difference between the private arbitration and private-public arbitration. If it is the state is one of the parties, also still they need to comply with the principles in terms of the appointment of the arbitrators. So this is one of the concerns. Then there is an argument regarding the no independent regulator, DGCA, and even actually the Bureau of Civil Aviation Security are all under the central government, under the direct control of the central government. But then again, there is a debate between should that be independent regulator, should that be government controlled regulator. There is a lot of debate in the public domain, so let me not delve much into that. Economic regulation of civil aviation, this is something which is very crucial. If you look under Section 10, when it speaks about making of the rules, Section 10E mentions about economic regulation. It was there also under the 1934 Act earlier, but unfortunately, we haven't taken it very seriously. Tariff regulation is something which has been left out. Market-based tariff the fixation has been one of the major concerns, and we have evidenced it's the flip side in the Chennai floods, 2015 Chennai floods, when the airlines increased the tariff 10 times, 12 times more than actually what was normal during the flood situation. One can imagine. Similar thing has happened during the Kerala floods, but then DGCA stepped in to control. At that time, they went ahead with actually the guidelines regarding the tariff regulation. So therefore, that's something which I'm looking forward. Some specific rules need to be developed with respect to the economic regulation of the tariffs, right? And another thing which is missing in terms of the rule making is the deregistration of aircraft. Section 10, when it speaks, Section 10H speaks about the aircraft registration. But there is no provision which is specifically mentioned about the aircraft deregistration, which is equally important. Of course, I'm not saying that this is a problem, because Section 10(1) says that with respect to any matter, the central government can come out with the rules. There is no problem. So, and Section 10(2) says that without prejudice to the generality of Section 1, these are the areas where the rules can be formulated. That's what it says. So therefore, it's still covered under the 10(1) umbrella. However, when we have enlisted 35 other areas under Section 10(2), we should have also enlisted deregistration. Registration would not include deregistration. Registration includes only refusal to register, not deregistration. And deregistration is very important for the next thing, that is the aircraft financing. Deregistration of the aircraft is very important with respect to the aircraft financing. Because unless an aircraft, Indian registered aircraft, is deregistered, foreign lessor is not in a position to take back his the object. It has to be deregistered, and then he has to seek an export. So that is the very reason why Protection of Interest in the Aircraft Objects Act 2025 needs this process of deregistration in the proper manner. Now, the second legislation, the last week's one, which has been passed with respect to the aircraft financing, we have acceded to the Cape Town Convention as back as 2008 itself. Unfortunately, the Cape Town Convention and the protocol, which has been developed by UNITRUA, is primarily in terms of having ease of financing in the mobile equipment, which include aircraft equipment also. Aircraft equipment, railway rolling stock, space assets, all those different kind of things have been covered therein. Aircraft equipment is one of the major aspects therein, which is functional. Despite our accession to the Cape Town Convention, we have repeatedly failed to respect the IDERA under the Cape Town Convention. What is this IDERA? IDERA is irrevocable deregistration and export request authorization. That is, when a foreign lessor of an aircraft or an aircraft engine, right? Usually the aircraft engines are the leased, right? The companies will not actually say purchase all the aircraft, so engines, so they will lease it. When there is a bankruptcy, or when the debtor failed to pay back the money to the creditor or the lessor would like to get the interest, his interest over actually the asset. They would like to get back their asset as soon as possible to ensure that actually there is no recurring losses. They need to get back their assets. For that, Cape Town system says about something called as IDERA. That is irrevocable deregistration. You have to deregister the aircraft and then export request authorization. You have to allow the export of that particular object into the concerned the lessors of the country, so that the lessors can easily get the remedies in case of the default by the debtor. Unfortunately, we have not actually respected that for a long period of time. One, because initially DGCA had a discretion. It had a discretion in terms of actually the deregistration under the earlier aircraft the Act and rules, which has been amended in 2015 to make it as mandatory. Then second, 2016, we got the Insolvency and Bankruptcy Code, IBC. IBC had a provision of moratorium with respect to having access to the asset for a period of 180 days, 6 months. Once the insolvency proceeding starts for a period of 6 months, you can't lay your hand over the asset. That means by the time the foreign lessor gets the right to lay the hand over his own asset. Now the last week's enactment is primarily for the purpose of adhering to the Cape Town Convention and the protocol in its true spirit. We have very few sections therein, some 12 sections are there, and then we have copy pasted the Cape Town Convention and the protocol as the annexes, right? So this is going to be enforced in India, that's what has been mentioned therein. So obviously we think that, oh, fine, now the finances can credit in India. So the finances can come to India and give more finances to the aviation industry in India. Problems, there are few, stay. I wanted to show that those sections respectively. To be very precise, section 9 is one of the major contentions, one of contentions. You have two subsections under section 9. First one, in the case of any inconsistency between a provision of this act and any other law for the time being enforced, the provisions of this act shall prevail to the extent of such inconsistency. So a non-abstensive clause, you can find that it is superseding other legislation. Foreign lenders might think that, oh, we have a safe haven in India. This legislation supersedes everything else. But read subclause 2. Subclause 2 says, save as otherwise provided in this act, the provisions of this act shall be in addition to and not in derogation of any other law for the time being in force. Legislation should have had either of these two, not both of them. Either you should have an overriding effect over other legislation, or alternatively it should be considered as in addition to the existing the laws. But both of them have been mentioned therein in a way a contradiction. And consequence is that if you read subclause 2, obviously other laws are also equally applicable. And one of the requirements under the Companies Act is that a charge has to be registered under section 77 of the Companies Act for the purpose of considering that in the process of bankruptcy. In the bankruptcy proceedings, insolvency administrator would look into those charges which are only registered under section 77 of the Indian Companies Act. And if a foreign lessor or a foreign creditor has not registered that under section 77, insolvency, the liquidator will not consider that. Which is right against the principle which has been mentioned under the CTC. Cape Town Convention specifically says that once IDERA is there and once there is an international registration, you have an international registry under the Cape Town Convention. Once there is a registration, automatically you will run into the priority. There is no requirement of compliance under the domestic law in any other thing, which has been taken off by virtue of this. And I would like to also say that this is in contravention of the VCLT. Vienna Convention on Law of the Treaties, section 27, article 27 to be very precise, clearly says that you can't take a defense of your contrary domestic law against your international treaty obligations. So therefore, this is still a kind of a problem existing. Couple of more minutes.
Sure. I have you a lot of time.
Right. Okay. Yeah. I know that we started with learn. Yeah. All right. Then section 9, there is one more provision, subclause 3, which says the provisions of this act or the convention or the protocol shall not affect the rights of the central government or any entity thereof, or other provider of the public services in India or any intergovernmental organization with India as a member. Okay, right? And arrest or detain an aircraft object under any law for the time being in force for the payment of any amount due to the government of India or any such entity. Right? I have highlighted those portions. So, with respect to any dues, with respect the debtors due or maybe the airlines due to these entities or government might result in those entities or the government taking a right over the asset. That is possible under section 9.3, which is under article 31 1B of the Cape Town Convention. That's a declaration which is possible under 31 1B of the Cape Town the Convention. We have made a declaration which also did not make any sense. I wrote a critical piece on that last year in the Uniform Law Review, the Unidrova's journal itself. it did not make any sense. It still continues therein. And now they have made changes in section 9. While making section 9 also, they still, I mean, of course, they made it better when compared to the effects of the declaration. Still, there is a problem. Problem is that it is saying any entity thereof. It is not any entity thereof. It should only be the governmental entity. It should only be the state entity. Article 31(1) B is very clear that it should only be the governmental entity which can get that exception. It is not any entity thereof. Right? So a private entity, unless and until they are involved in the public services, because you have other providers of the services in India, public services in India, if it is not providing the public services, it cannot claim this exception under section 9(3), which is a problem for a foreign creditor in most of the cases. The last slide, with respect to jurisdiction and entry points. Section 8 of the new act speaks about the jurisdiction of the High Court, respective High Court. Of course, this is also in tune with our own declaration under Article 53 of the Cape Town Convention. We have declared that the respective High Court will have the jurisdiction to deal with the matter. It's in consonance with the declaration, but the problem is that we are not recognizing the ADR mechanisms. Foreign creditors or lessors are less interested in approaching any High Court for the remedy. They would like to have some ADR mechanisms which would be easier for them to get the remedies immediately. They don't want to actually sit in the High Court for 6 months, 1 year and get a remedy and thereafterwards having access to their assets. So precisely because of that reason, we have to reconsider and we may have to actually allow even the alternative dispute resolution mechanisms for the purpose of having matters settled under the Cape Town system. Finally, section 10, again, it speaks about power to make rules. So interestingly, section 10 of both legislations speak about the power to make rules, right? The ABA also says about it, and then the Cape Town Convention, the Act also says about the power to make rule under section 10. Here, something which we need to consider in terms of making the rule is to designate the entry point or entry points with respect to the international registration of interest. Because under the Cape Town system, there is only an international registry, online registry which is available therein. However, the registrar is not having any obligation to look into the validity of the consent. Because the registrar is not in a position to do that. Sitting somewhere in Ireland, will not be able to actually say map whether the debtor and creditor actually had an agreement in terms of the financing. They will not be able to map it. So precisely because of that reason, the validity of a consent is not going to be mapped by the registrar. There is always a possibility of the interest registered in the international registry, which is not valid under the municipal law. There might be a possibility of that, which would completely destroy the system. You will not be knowing about the priority, whether the interests are actually correct interests or is there actually any kind of a problem with the prior registered interest. Nobody knows about that unless and until you have a filtering point. And Article 19 of the Cape Town Protocol, the aircraft protocol, specifically says that you can designate the entry point or entry points for the purpose of transmitting those information, which can be a checking point, right? The validity of the consent can be looked at the state level itself. So I would say that in terms of making of the rules, we should bring in the entry point or entry points so that those interests which are registered from India are not something which are invalid interests under the municipal laws. So these are the few comments with respect to the two legislations. Thank you so much. I will be happy to answer any questions with respect to that. Thank you.
Thank you, Dr. Bhatt, for this excellent presentation. I'm sure that students would have made lots of notes, and you raised some of the very vital points vis-a-vis Cape Town Convention. It has recently been passed by both Houses of the Parliament and it awaits President's signature. So those who are interested in aviation law may wish to follow the developments as and when the President signs this particular bill. It will become an act, of course it will be notified by the government in the Gazette. One of the issues that you mentioned, Article 39(1)B, dues, what can be claimed and what cannot be claimed, who can actually claim, and who should be paying those dues actually, whether the lessee who is defaulting or the lessor or the IDERA holder, it can be a financier as well, who should actually be paying. And this, question becomes very interesting actually. And thankfully and luckily we have sitting with us Mr. Kharbanda, who is the Chief Legal Officer of GMR Airports. May I ask him this question that, in his views, how can this entire issue of dues to airports be handled? And from an airport's perspective, what do you think would be the right thing to do?
Actually, all these aspects were dealt with long back after there was a pressure on the government of India to deal with and implement the Cape Town Convention. I remember in 2018-19, Ministry of Civil Aviation was in touch with all airports and airlines to see how to handle this aspect, including DGC and other stakeholders involved in that. Certain processes were evolved during those discussions, keeping into the consideration interest of all. And in that process, a timeline was also set out where today airport operators have been asked to deal with their dues basis their arrangement with the airlines, subject to they being able to recover the dues from the lessor for the aircraft for the last 3 months from the date of IDRA issued by the lessor. And then the process is also set out how that will be given to TGCA, to the airlines, to the airports to confirm their dues to TGCA as well as to the lessor, and for them to pay and take the aircraft out. So those aspects are so far maintained even after enactment of this new law, because those were captured in the rules, and rules have not yet been new rules have not come into the play. So till that time, though there is some ambiguity in terms of provisions, still those rules are in place, and those are being governed by basis that itself. We have seen that more prominently applied during our recent Go Air related issues, and also now being dealt with in the Jet Airways as well. So I hope today there is some mechanism available. We'll see how that further develops in these rules through consultation with all the stakeholders by the ministry.
Thank you, Mr. Kharbanda. We have, some time left in our hand, and you should take advantage of this. And why don't I ask you one more question? That airports are extremely important, and various presentations and even the opening notes, we noticed that the aviation is poised to grow in India manifold, and that would present various opportunities as well as challenges. One of the challenges would be how airports would cope up with the demand and the capacity increment. So, in your view, what are the ongoing challenges and future challenges that the airports may witness, and how to address those? Thank you.
Currently, the infrastructure, government has a lot of thrust to create a new infrastructure, replacing the existing one with more modernization, more facilities, technologies prevailing very high in terms of every aspect of the business, including the airport business. And in that pursuit, many airports have been privatized, or private players have been asked to join hands with the government. So a lot of state governments are also very keen to come up with the new airports, greenfield airports at this stage. So in that context, demand-wise, meeting demand of the passenger needs is there. Yes, more pace needs to be applied by the government on this aspect, particularly the central government. What I see major challenge today, particularly on the brownfield airports, is the protection of environment, because all these airports today are becoming part of the city, and airports are something which generate a lot of energy. Aircrafts burn a lot of fuel. So all these aspects need to be very carefully handled. A lot of work is happening today. Means when we see the new airports which are coming, they are more green energy. When I look at the Delhi airport, particularly the GMR airports and the new airports on the GVK earlier or Dari side today, they are applying more thrust on creating environment friendly airports with less consumption of energy, applying more new innovative ideas to preserve the environment. But still a lot needs to be done, many areas which are yet to be handled on this aspect. So environment, I see a major challenge in this growth of airport sector.
Thank you, Mr. Karwanda, for these excellent answers. I know that we may not have left too much time, but I cannot let this opportunity go and not ask Dr. Sachdeva a few questions. I know that you made a case, and of course supported by various conventions, that in case of a mishap, airlines, they owe a liability or a duty to compensate the passengers. But are there any circumstances, wherein an airline will not be liable to compensate any passenger if something goes wrong, or they are required to pay in any circumstance whatsoever?
This question concerns development of aviation law. There were many exigencies and contingencies which air carriers did not admit. That's where I started with the earliest portion of mine, where there were hedge clauses like ad impossibilia, where the airline said, okay, it was impossible to avoid and the accident happened. Or it was a force majeure, it was an act of God and nobody could have worked otherwise. And they were trying to work out possibilities and advance arguments where they could get off the hook of liability. In fact, it's a general sort of a trend and everybody does it, most of us. So airlines, as it is, always had an attempt to do that. Even when it came to finalization of Paris Agreement and Convention, or later Warsaw Convention, and even Montreal Convention today is a sheer reiteration of what was there in the Warsaw. Over the 50, 70 years, we haven't learned anything. And the airlines are not willing to concede even the genuine interests of the passenger. As I mentioned, the case of airports becoming sprawling complexes with a lot of facilities and things like that, and a child died at Delhi. The case lingered on for 5 years till Supreme Court had to rebuke them all and say nothing doing. It shall be paid. And it was not only paid, it was paid at full death rate, which was under the Warsaw Convention, and at 10% interest. 10% interest. You can imagine the insensitivity of not only the airlines, but also the other agencies they implead into such, because the services are provided by another agency. And so far as the air carrier is concerned, they say our responsibility is only to carry. But you got to carry the passenger undisturbed, peacefully and safely to the destination. Does it happen always? And particularly when an accident occurs. Today we have reached a stage where when an accident occurs, a passenger has no access to any evidence. It's all a barricaded area and security is there to protect it. Oh, they want to do the investigation. And passenger has got nothing to do with it, though he's the affected party. That's where in the Warsaw Convention they had created a provision called the facts speak for themselves, res ipsa loquitur. That means under the law, the passenger doesn't have to explain what happened, how it happened, what is the fault, he doesn't have to prove the fault. He just has got to say, I was a bona fide passenger with a valid ticket, accident happened, and these are my injuries. These are my injuries. Res ipsa loquitur. And then the question came, okay, you can say that this is what happened to me and you compensate. But most of the airlines said, yes, we'll compensate you. You had an injury, we'll give you the medical expenses. Or the injury is filled up already. the question of intangible injuries, like person having gone through a trauma gets into sleepless nights and nightmares for a long time or maybe a lifetime. How do you compensate that? How do you evaluate that? And that is where it was only the United States which has come to the help of the passengers.
The discussion will not be complete without we speak on the drones issue. It's very relevant topic these days. In your view, Dr. Bhatt, you think that India is well poised to lead the drone industry? And what do you think we stand? Where do we think we stand in terms of the technological development in drones? Thank you.
Maybe in terms of technological development, I am not the right person to answer it. From the legal perspective, let me just tell my views. As all of us know, so we have moved from prohibition to maybe regulation. So initially we had a prohibition with respect to the use of the drones. Now the new policy goes for the regulation. I still find certain concerns. So one of the things, there has been a ban with respect to the import of drones from other countries. 2022, the ban has come up. But I'm not very sure whether there is any notification with respect to removing that ban. I heard from the industry, just I had a casual talk with one of the resource persons here just in today morning, that we are still importing drones. We're still importing from China. I mean, it's still by the private companies. As per the policy, it is only, as per the notification, it's only parts of the drones which are permitted, not actually the drone per se, so we cannot import the drone. And I also remember soon after the notification came in, all those toy drones in the stores also all vanished. So even the toy drones were also not available at that particular point in time. But I don't know currently whether there's any lapse in terms of the enforceability of this the ban. But whatever it may be, I think it is for the good. Because if we impose such a kind of a blanket ban with respect to import of drones, and we think that we will develop our own technology and then we will be able to catch our market, it is going to be counterproductive with respect to our sale in other markets. When we impose the ban, obviously they would also impose ban on our product. It's a kind of a quid pro quo. I mean, I also teach international trade law. So precisely because of that reason, so it has got a kind of a cascading effect. So if you ban, obviously they would also retaliate with a similar kind of a ban. With Indian industry, which might be capable of producing the drones in a cost-effective manner, of course, might not be able to compete with China too much. We know about that. But still, China will not be able to get the market in certain countries like United States or maybe some other countries, European countries and all. They would not be able to establish a good market when compared to that of India. So precisely because of that reason, maybe by removing this kind of a ban, except subject to the security exceptions. Obviously, security exception is something which we can incorporate. But apart from that, by removing this ban and then making more and more production in India for the purpose of exportation as well as catching the Indian market itself, we would be in a better position with respect to the drone, and probably we might also have a kind of a global market and developments in the drones. This is my personal view. Thank you.
Thank you, Dr. Bhatt. Of course, international trade and tariff are the hot topics these days.
Yeah.
With this note, may I open the floor for the audience? Please raise your hands if you have any questions. Thank you. If you can arrange a mic, yes, please come. Thank you. Voluntary, can you assist? Or maybe, sir, you can ask your question. We can then repeat the question for the audience. We can hear you. Hopefully.
Yeah. So I'm Bajit. I'm from Ministry of Petroleum Directorate. So my question is, it's a very good presentation by your panelist member. So privilege we can hear and opportunity was given. But what I'm saying is, in terms of a passenger liability or maybe liability of the aviation, aircraft or the company. What is happening is, in India, many companies have become bankrupt. Actually, now only few players are there. Should we not have a very right balance? Actually, too much leaning towards passenger liability. If we impose, it will further challenge their economic viability. Actually, for example, we are seeing a lot of cases like AC is not working. Also, it is getting highlighted too much of the aircraft. So, okay, while it should work, we are not saying that, but there should be a very right kind of a balance where industry also progress well, and we should be more towards the industry also now because very few players are there, and I am seeing very dominant player now in the aviation sector is being very frequently questioned for very small petty things. So there should be some kind of a restriction on too much on the Twitter we are telling against the aviation sector. I feel that also should be considered. Any view?
Thank you, thank you. Of course, questioning is a part of freedom of speech in a democracy like India. I believe your question is directed towards Dr. Sachdeva because he can speak with authority on compensation and passenger and airline liabilities.
Thank you for the question. Now, the point at issue is there are certain actions which become criminal while in the aircraft, though they can be sorted out under criminality and have been done. There was a case of a passenger who urinated in a coffee mug and the aircraft landed in Singapore. The Singapore court took cognizance of that and that person was fined. Firstly, would such a thing happen in India? The question is not, it's an airline compensation. It could be the airline can implead that person into it and say, okay, you become a party to this. There is a provision under law where you can implead another party who's more liable for it. And secondly, what the airlines are doing is the easiest way out. They hand it over as a criminal offense. And so far as they are concerned, they say, okay, we have put this passenger on the no-fly list for 1 month. And there again, there is a disparity between no-fly lists. There are no-fly lists with every airline, and there are no-fly lists with DGCA. DGCA lists are the ones which are applicable to all airlines, and the independent airlines are only for that particular airline. So where is the punishment? Just don't fly for 1 month. Is that what exactly can be equated against the indignity, inconvenience, shame, or whatever else you can call it? Number two, it could be possible that airlines in the beginning will not be able to do that. But over a period of time it will happen that they become more sensitive to this. And not only that, they're sensitive to the activity. They screen passengers a little more carefully. And wherever we have the no-fly lists, they can be made mandatory. They can be made mandatory so that all airlines take cognizance of that. And I've left a thought with you. I've not given a solution.
Thank you.
I've left a thought.
Thank you, sir. I have now been asked to vacate immediately, so I'm very sorry. We will not be able to take any more. Okay, yes. Yes, please.
I'm Tala from Aviation Guide and Air Cargo Update. Hello. Yeah, my question is for Professor Sandeep Bhatt. Given the rapid adoption of AI and autonomous technology in aviation, what legal and ethical considerations should be prioritized to ensure compliance without stifling innovation?
I think it is something which is applicable in every sector. You were telling about AI primarily in terms of use of AI. So the ethical considerations which are there in all other sectors are also there in the aviation sector. First thing is about privacy, right? Issues with respect to the privacy in terms of the use of AI. the data being collected, transmission of the data. This is something actually which is crucial. Then another aspect is that AI is trained in a particular manner. It's trained in a particular environment, particular manner, which might not be suitable in every environment. Right, so AI which is used maybe in a Delhi airport might not be suitable for a Mangalore airport or a Tier 3 airport, especially because it is tailor-made for an airport having huge passenger the flow. So these are few things which need to be considered, but at the same point in time, I always support use of technology, because in fact in the last airport research which we have done, one of the major problems which we have seen in India is the facilitation. Annex 9 of the Chicago Convention speaks about the facilitation, smoothing of the journey of the passengers, cargo, etc. We still find, as Professor Deva said, for an international flight, we need to go 3 hours in advance. Or maybe a domestic flight. So for example, I fly from Bangalore to Bangalore. So it's just a 35 minutes the flight. I have to be there 2 hours in advance in the Bangalore. So it's like that. So precisely because of that reason, use of AI is definitely required, development of technology is required, but few of these ethical and legal considerations need to be kept in mind, and maybe it should be tailor-made to the respective airports or respective airlines, for whatever it's being used. Thank you.
Thank you so much.
Thank you. Thank you. With this, sorry, there are few hands. I don't know whether I'm allowed to. Yeah, sorry, sir. We are running a bit late. What you can do? Maybe you can reach out to the panelists, separately after this.
It's a very special.
Okay. Thank you. One last question.
We are talking about. I am Dr. Damonari. So this is space tourism. We discuss about it. See, this is one of the maximum foreign exchange department. But we are talking about this for many decades. But it is not materialized. Is it any legal restriction? Please.
So this question is directed to?
No, I know I can answer this also. It's all right, because I also write in the space law, space tourism.
Thank you for
As
this.
of now, there is no prohibition in terms of the space tourism per se, because see, most of the countries are not even having the law. India is yet to have the law, so we are expecting this year. So we are also part of the drafting committee. So it's expected this year. But there would not be any prohibition in terms of a space tourism. What is more important is the sustainability with all the activities which are already going on, how far the space tourism is sustainable. And then another important thing is that usually in the space activities, orbits are allocated by the ITU. You have an orbit which you are using for 3 years or 5 years, whatever it might be, for orbiting a satellite, and commercial use of that would be made. But in space tourism, what happens is that there would be random entry into the orbit, which might create a lot of actually chaos with respect to the space traffic management. So these are the things which need to be kept in mind. But otherwise, United States basically allows the space tourism, and in fact, its law says that there is a requirement of only taking an prior informed consent with the tourist that the launch is not safe. Apart from that, they don't actually have any other restriction with respect to the space tourism, right? So it is permissible as of now, but it should be regulated. That's what is the basic thing.
Thank you, sir.
Thank you. Thank you for being the wonderful audience. Thank you so much.
Thank you so much, first of all, to our esteemed panel for having this enriched discussion. We are grateful. I'm sure, when you are listening carefully, that is only when you have questions, because you wouldn't have questions if you were not listening. So thank you for the questions. I'm sure that we'll have our doubts and we can take on one by one with the panelists if they're around. I'll request the NLU team to please come forward. Before that, we'll request Dr. Garima Tiwari, NLU Delhi, to please step forward, and we'll request, we have with us Professor Dr. G.S. Sachdeva. Please help us to felicitate. Thank you so much, sir, for joining in today and being here with us. We'll also request, ma'am, please help us to felicitate Dr. Shri Ajay Kharbanda ji. Everyone, can you please put our hands together one more time? Thank you so much, ma'am. Next up, we are felicitating Professor Dr. Sandeepa Bhaji. Thank you so much, and Shri Ajay Kumarji. On the stage, we have Dr. Kenthor Lamar from NLU Delhi felicitating. Thank you so much once again to all the panelists for being here with us. I'll request the NLU Delhi team to please come on stage together for a group picture with the panelists.